quick announcement on the WireWheel side. We're very excited to announce that we've just launched our new universal preference and consent platform. It's now generally available. And our new platform is really addressing those critical needs, specifically around some of the new laws in the United States and globally. And we're really, looking forward to working with companies, helping really solve for some of the new requirements around the country, especially around the Sephora enforcement decision in California.
Great to see everybody on our second day here at Spokes. And we had a phenomenal opening set of sessions yesterday. We covered, obviously, age-appropriate design, including issues under the new California law. We covered a very lively discussion about the new enforcement actions, including the Sephora decision and enforcement action. We had the lead negotiators for Europe and the United States on the new EU-US data privacy framework, and terrific discussions analyzing the framework. We also had a terrific session on virtual reality. And we get to pick it up today on a very important topic for the privacy and digital marketing and ad community, talking about with some of our leaders from the advertising world, the next year, with 5 separate state laws coming into effect and regulators around the world really looking at ad tech and martech from a number of different angles. So I'm delighted to introduce our 2 experts and panelists today. From the NAI, Farah Zaman, who is the VP and General Counsel of NAI. Welcome, Farah. Great to see you here today. And Michael Hahn, who's the Executive VP and General Counsel at IAB. So Michael and Farah, welcome. For those joining us here today, I'm just going to cover this briefly. Donna Fraser from BBB, who is a longtime, the BBB National Programs is a longtime partner of WireWheel, and Donna has been part of our spokes community for years. She was called into an important meeting this morning and couldn't be here, but we're delighted to have Michael and Farah with us. I'm going to turn it over briefly to each of you to talk a little bit about your backgrounds and also about the NAI and about IAB, just to talk a little bit about its history and where it, kind of the role it plays for your community. So Farah, do you mind if I turn it over to you first to introduce yourself to the community and what NAI does?
Sure, I would be honored, and thank you so much for having me. I'm really excited to be here with all of you. I think one of my favorite things about working at the NAI is I've known them through my whole career, long before I joined them about a year ago. So, the NAI is really the leading self-regulatory body, especially in the privacy space. And I think that's something unique about us as a trade association is our, mission and our focus has been privacy since it was founded over 20 years ago. And that's really the value add that we have always had for the industry and that we continue to add. So our traditional membership is really what we call the pipes of the advertising ecosystem, and that's ad tech companies. And, again, I can say as a practitioner, the first way I heard about the NAI was when I was a baby attorney at Nielsen. And it was, we are not going to do business with ad tech companies that are not NAI members, because that was really the gold seal for the good actors in the space that have, comprehensive programs, the right type of practices and governance in place to make sure that you're really not having those nefarious bad actors there. And then from there, I've had the privilege of working at a brand and a publisher before coming here, and I've just continued to grow my understanding and my relationship with the NAI, which is the NAI is really working on being the proactive #1 authority for privacy for the advertising community. And, while our core membership continues to be ad tech companies, last year we announced the opening of working groups to really invite advertisers, publishers, agencies, and law firms or vendors to come join and help come up with what are the solutions, not only to address the regulatory challenges, but so many of the technological changes that we're seeing in the ecosystem. And I can go on for 2 hours, but I want this to be a conversation. So, happy to talk more about the legacy programs, also what we're doing to address the changes. But really for those in the audience, just to know that the thought leadership that the NIA has done historically on issues like sensitive health or precise location are areas we're continuing to lead and really develop practices and assessments so that that there is a proper due diligence in place for those partners you're working with, and really want to work directly with brands and publishers to help build those new assessments to address the new challenges.
Farah, that's terrific. And as I said, welcome and thank you for joining us here today. We're going to give you a chance to talk about a lot of those different subjects, including, some of the things that NAI has been doing for the community historically. And that brings us to Michael Hahn. Michael, obviously, the IAB has been doing an unbelievable amount of work on these areas as well for years. And you've released a number of things at IAB to help the community tackle this group of state laws that are coming into effect. So we'll give you the same opportunity to introduce yourself, give a little bit of your background, and if you don't mind, talk a little bit about IAB's role with the community at large.
Sure. Well, first, thank you for having me here today. Really appreciate the opportunity to speak to the WireWheel community. So I serve as the EVP and General Counsel of the IAB and the IAB Tech Lab. And those organizations represent the big tent of the digital advertising industry. Our membership of 700 to 800 companies covers publishers, advertisers, their agencies, and ad tech companies. And so I like to think that our mission is, especially in the area of privacy, is to tackle the biggest problems where we could get all of the relevant players to sit down to the same table and come up with common sense solutions that comply with the law. And so we very much have been mission driven in our IAB Legal Affairs Council, which is the group within the IAB that I lead, as well as at the IAB Tech Lab, where we are promulgating technical standards to help facilitate privacy and more generally to help facilitate digital advertising transactions from the original specification for OpenRTB, which allows for programmatic transactions to happen, to our most recently released global privacy platform, which we'll probably talk a little bit more about later today, that allows for industry-wide signaling of consumer privacy preferences. In terms of my background, many perhaps don't realize that I began life as an antitrust lawyer, and before evolving into privacy. And digital advertising was one of the first cases, or one of the first verticals that I handled. And I actually remember one of my early cases began in 2006 and concluded well after I had taken this job in 2019, if that gives you a scary sense of what that job is like. So with that, I'm pleased to be here today and happy to chat with both of you.
Well, listen, perfect. I didn't know that, Michael. I didn't know you were an antitrust lawyer. I think we can bring that up along the way. And Farah, as we go, we'd love to hear a little bit about the kind of issues you've been handling in your career too, because it always kind of informs, the discussion as we go. So I'm going to jump in, and I think in order to kind of level set a bit, I might start with just talking historically about some of the programs that NAI and IAB have run that touch on some of the major issues that are coming up next year. We don't have to cover this with the history of IAB or the history of NAI, but if you wouldn't mind giving a few minutes on some of these major things, for example, Michael, at IAB, you've had legal frameworks and, original versions of some documents. You obviously at IAB also sponsored some of the major standards with TCF in Europe. Just even defining terms for the community, I think, is often helpful. Michael, if you wouldn't mind. And Farah, at NAI, you've been running a number of self-regulatory, run programs for years, if you wouldn't mind, self-certification and others. If you could just cover historically what role both organizations have played for a moment, just so we can level set. I'll start with Michael, if you don't mind, first, and then come to Farah next.
Sure. I like to think of the IAB lane has been the legal compliance lane. And so, of course, when you look at your own companies, there are a number of different aspects in which you think of legal compliance. There are those things that you need to do behind the curtains to ensure that you're going to comply. Do I have the right opt-out up on my site? Am I sending out technologically to various databases to suppress when consumers opt out? But there's also another component of compliance, which is how do I interact with all of these partners in a highly complex digital advertising ecosystem in a compliant manner? And, to a certain extent, that's where there is a tragedy of the commons that exists, where IAB tries to step in and help create common baselines, common frameworks, common contracts, so that we can solve for these common privacy law challenges. And that really first materialized historically with GDPR, and our affiliate in Europe, IAB Europe, took the lead in promulgating a framework to facilitate compliance with the law. That is the IAB Transparency and Consent Framework, better known as TCF. And this involved bringing together a wide range of industry actors over the course of several years, because it was constantly being improved. There were different versions of TCF, and trying to determine what are the parameters that we need to be able to have as an industry to obtain consent and tie them to the multitude of purposes in which personal information can be used in Europe. And in that endeavor, IAB Europe partnered closely with the IAB Tech Lab, because it's one thing to have this IAB TCF contract that everyone signs up to in a common framework. It's another thing to have the ability to signal in a manner that is that everyone can recognize and build to. So IAB Europe and IAB Tech Lab partnered together to build the blueprints for the technical infrastructure for the signaling of the multitude of different purposes in which personal information can be used in Europe. Fast forward to 20, maybe it was the middle of 2018, and when CCPA first became a thing that people were talking about. And pretty soon in the United States at IAB, we began to galvanize our membership to try to come up with a common approach to dealing with CCPA, which this was the first state privacy law in the United States. And there were many who said, let's just do what we did for TCF in Europe, and we could just call it a day. And that was easier said than done, because as many of us now know, right, CCPA looks very different than GDPR. And the signals would need to be different, and the obligations are certainly different. So it required us to get to work in an extraordinarily short period of time, in the same way that all of our member companies were scrambling to comply on a very compressed time frame. At an industry level, we were doing the same thing. And from that, we developed the IAB Limited Service Provider Agreement. And that became an industry contract to facilitate compliant transactions, relying on the use of a technical blueprint that the Tech Lab put out, a string. It's called the US Privacy String, which would allow for companies to signal that the consumer has opted out, that they provided notice, or perhaps they didn't opt out, and allow that signaling to go through the ecosystem. The limited service provider agreement required the use of the U.S. privacy string. It also set parameters for what generally needed to happen for notice and opt-out, and that when the consumer opted out, there would be service provider relationships that would trigger into place between publishers and ad tech companies. So that became the genesis of what we did, and then we certainly had discussions with the regulators around that, and we had a successful run with the LSPA with 1,000 signatories, and I think it got a favorable review from the regulators. And of course, we've been busy over the last year figuring out how do we evolve the LSPA into the MSPA, which is the multi-state privacy agreement, to address compliance across the 5 different state laws. So with that, I've now given you a tour de force, and I am going to cut it off.
Well, Michael, that's perfect. But I think what's important is, like, for our listeners, in many ways, IAB and IAB Europe are playing and have been playing a role to actually put legal agreements in place and signaling mechanisms in place to help companies directly comply with the laws. If, I don't want to rephrase what you said, but some of the elements you covered it's important to understand the role that IAB has been playing historically on it. Again, you can correct me here if I'm wrong on any of that. Please don't accept my, kind of characterization of it. Farah, do you mind giving a little bit from your side as well on the role NAI has been playing in setting up self-regulatory regimes to date here and in other parts of the world?
Yeah, I would love to. And I'll focus more on the history for this question. But I loved this morning, Justin, in one of your LinkedIn posts, you said, digital advertising is becoming a regulated industry. And that's 100% true, but that doesn't mean that there aren't actors who are used to kind of self-governance in the space. And that's really the role that the NAI played. So the NAI was founded over 20 years ago, and a lot of it was to kind of bring together and create standards and governance for what has been the Wild West for a long time, and kind of what the industry came to rely on the NAI for is that knowing that NAI membership really did have comprehensive privacy programs before legislation required. So the way our membership works is you apply to be a member to the NAI, and then really you have a one-on-one intensive kind of review, almost an audit of your privacy program with our compliance team. And that's very interactive. So it's not just kind of fill out a questionnaire and you're done. It's interviews, it's, viewing your privacy policies, your disclosures, your contracts. It's pretty comprehensive. And then also giving feedback, because the number one goal that the NAI has always tried to play is to help companies get into compliance, right? That kind of lifts everyone up together. So, if you go through that process, you're accepted, you make the modifications to kind of comply. Then as a part of that process, you get an annual review. And that, again, goes over your disclosures. It tests your opt-out mechanisms. It looks at your contracts. It also does product reviews for new products that might be using new data or new technology. And that's through that kind of process over the years, we've developed specific best practices and guidances on some of the most difficult and nuanced issues for the industry. And then our members, are beholden to those requirements and are reviewed on an annual basis. So, really what that helps do is essentially it requires our membership to do partner vetting, but it also lets those working with our membership know that those companies do have, a due diligence program essentially that they can rely and trust on. I'm really passionate about, we've done work in a lot of different areas, but I think sensitive location and sensitive health are historically, some of the most well-known and beneficial programs. And I will say in my time as a publisher, when I first came from a brand over to working at a publisher, and you talk about all the different types of opportunities sales teams bring to you, I'm a really big fan of that front page news test, right? Do you want a write-up that's saying your company is doing X, Y, Z, and is that going to raise, a consumer trust issue or a brand safety issue? And there really wasn't guardrails when it comes to the use of a lot of types of health data. And that's where I ended up implementing NAI's sensitive health requirements at the publisher I was working at, because it really gave, a roadmap. It gave some do's and don'ts. It was something that there's kind of industry alignment for kind of the ad tech community that are members of the NAI. And I think that's really an important role that the NAI has served historically, is coming up with some of those standards and best practices where, there's not even legislation, let alone other standards. And I think it's really important from a brand safety perspective. And NAI has done some of that thought leadership on these issues. Obviously, we behold our members to it, but it's also things that can translate and apply to other parts of the ecosystem.
Lot to cover based on what we even have introduced to date, because we've covered the role of each organization. We've talked a little bit about the role of self-regulatory regimes and direct compliance regimes. And now we come to 2022, 2023, where there is a lot of regulation coming to ad tech and MarTech this year. And the way we have been thinking about it, Farah and Michael, is the US still remains, until there is a nationwide comprehensive law, we still remain a community and a country that is still sectorally regulated when it comes to privacy. And whereas in Europe, for example, there is a sort of an overarching law, which means they have the ability to require that any use of data is subject to permissions or a basis for processing. Here in the US, when it comes to consumer choice, for example, it's still sectorally covered, and only certain choices must be presented to a customer. So we're coming into a year where we think of ad tech and MarTech effectively becoming a regulated industry in the US, with California, Colorado, Virginia, Connecticut, Utah, all having, state laws that focus so much on ad tech and MarTech. And it raises some interesting challenges for the community. Let's give you both a moment to talk about this. And Farah, I'll turn to you first, if you don't mind. So now, as all of these state laws come into effect, and you have regulation applying directly, effectively to brands and publishers and ad tech and MarTech itself, what's the role that NAI is really focused on as you're going forward? And then Michael, I'll let you pick it up on the IAB side as well. Farah, over to you.
So I think we're continuing to evaluate our programs and our processes and how they align and intersect with state regulations, which are still forthcoming, right? We still have more draft regulation and implementing regulation coming down. So, while we're also doing that for our legacy programs, we're really looking at our membership is kind of the most familiar and best suited to deal with this complexity of requirements, because, I kind of already cannibalized my answer here, but our self-governance program has a lot of those key elements that you're seeing with the state laws. We have annual reviews, we have privacy policy disclosure requirements, we have notice and choice requirements, partner vetting. So, the key parts of our program are really what you see replicated across these state laws before you get into kind of the nuance of what separates the different states. So, that is not new for our membership, but we're also happy to partner and help educate and mentor kind of the other parts of the industry where maybe this is a newer, steeper cliff. Part of what we're doing, again, in the working groups that we've set up that are inviting other parts of the ecosystem to join, is working on developing new assessments that are responsive to some of those new requirements. So, really an open invitation. Feel free to message us directly if there are things from your compliance perspective that you want to know and see in the companies you're doing business with. That's something that we're working to update our process to make sure that it's serving that purpose for the larger industry. I think in addition to that, one of the things that we're looking at is really how do we, I think, this is me taking off my NAI hat, and as someone who's worked in-house at 3 positions and developed 2 programs, I think really what is effective when you see the myriad of legislation is taking a principles-based approach. And I think that's where some of these governance standards and policies really come in place, of really holistically saying, we as a business, right, what are our priorities, both from a PR perspective, from a compliance perspective, from a consumer trust perspective. And I think understanding and thinking through that relationship is something the NAI has a lot of experience with, and is, looking to partner and continue to develop standards about. And I think the one thing I didn't mention that I really should have, Justin, is that we have historically offered a consumer opt-out page for across the industry. So really a page where for all of our membership, a consumer can come and essentially opt out of the ecosystem. Now that is very much a cookie-based opt-out. And as we know, cookies are on the way to being deprecated. So kind of working through how those opt-outs change and evolve is something that we're working on as well. And we did release an email-based opt-out last year, again, trying to keep track of all the different ways that the digital advertising ecosystem is reaching consumers today.
Thanks so much, Farah. And I mean, it does help. And I'll come back to just, I think at some point, maybe we could talk about how self-regulatory regimes a little bit overlap when you're not overlap, like what's the role and how you think of it with the new legal obligations. I think that would be a great topic for us later on here in the conversation. And maybe with that, I'll pivot over to Michael. Michael, IAB's releasing, form legal agreements and also updated signaling mechanisms. Do you mind talking through some of the efforts that IAB has put in place over the last year or so around helping the industry with the new state law requirements?
Sure. So on December 1st, we released the IAB Multi-State Privacy Agreement, and this was a year-long effort of bringing together all of the different parts of the digital advertising industry to figure out, can we come up with a common contractual and compliance mechanism that could be scaled to 5 different states, which have some similar parts, but also some real differences as well. And after a year of work, I think we've successfully accomplished that. And in particular, we have created an industry contract. And so what does that actually mean? Because it's not something that replaces your commercial contracts. You still have commercial terms with your partners. But what this does is creates a common set of privacy terms that will apply to transactions that are covered under the contract. And in doing so, it allows the participants to know and understand that everyone who is in the digital advertising distribution chain is going to be meeting the same set of privacy terms, which are all designed and keyed to comply with the law. And so we've created in this framework, in what I like to think of as a springing contract. That is, you have a network of signatories, but they don't actually come into privity of contract with each other until a first party, a publisher, an advertiser who's a signatory says, I want this transaction to be covered by the MSPA. And then when they send the personal information to another MSPA signatory, and you can only send it to an MSPA signatory, as that data flows through the signatories, they have mini contracts that spring into place with each other. So in this context, we have really 2 modes of operating under the MSPA. We have what is known as opt-out option mode, and that is for those first parties who say, I'm going to sell personal information, I'm going to share for cross-context behavioral advertising purposes or targeted advertising in the 4 other states. We also have something known as service provider mode, where in service provider mode, that's for, and this is really some advertisers in particular who say, I don't want to sell personal information. I'm not going to sell, I'm not going to share, but rather I want to rely exclusively on service provider agreements. And so we provide both of those mechanisms for different parts of the ecosystem to operate in a manner that's compliant with the law. And we literally go through and say, for example, when service provider arrangements are triggered into place through the MSPA, what are the specific business purposes you can rely on that relate to digital advertising? And we go through this in a fairly detailed chart that is affixed to the contract. So we're really trying to facilitate transactions. The second component to this too is there are certain essential functions that happen in ad delivery and reporting, which are subject to consumer opt-outs because they involve the sale of personal information. If you think of measurement activities and frequency capping and those types of activities. We provide a scaled network basis to allow those activities to happen in a service provider mode, and cause publishers and advertisers to jointly designate, for example, maybe a measurement company to operate as their joint service provider, so that a consumer who has an experience where they go on a publisher page, they see an ad, they click into the ad, they go to an advertiser side, that whole transaction can be measured. And also, I think about, what's going to happen in a world in which we're going to have increasing levels of opt-outs because of GPC and greater consumer awareness. And in that world, you want to be able to do things like deliver contextual ads. But delivery of contextual ads through real-time bidding requires the sale of personal information because the IP address is disclosed. So we, again, create that network of service provider relationships. And then finally, what I would say is that our working group was busy this year trying to provide what I'll call the legal inputs that are necessary for the IAB Tech Lab to design the global privacy platform, which is, think of that as the pipes that everyone in the industry needs to build to, so that when a publisher and advertiser provides a notice to the consumer concerning their privacy rights, and the consumer makes an election, that everyone can comply with those elections. So that's what we've been doing this year, and trying to help everyone get to a state of compliance.
So between both NAI and IAB, it's been a very quiet year, it sounds like, for both of you. Nice and easygoing and relaxed with no big stressors. Michael and Farah, is that about right? Nothing.
Just another day.
Just another day. All right. Well, listen, that's a lot, and it's a lot to cover. Just so folks who are watching know, we have an entire session later on today at 1 o'clock Eastern, in which we're going to be covering the MSPA, the GPP, and we're covering it from both the legal perspective and the technical signaling perspective. So, Michael, I won't make you today go through the technical aspects of either of those items. Obviously, we should cover it a little bit more deeply. But now that we have some background of what's been going on at NAI and IAB, I will say for everybody, number one, if you have questions for Michael, Farah, or myself on anything, please record them to the Q&A, and we will take them up during the balance of the discussion today. We get a lot of questions on each of these items because it's complicated and it's new. So please record them. We'll cover them as we go. But we've also got a lot to talk about now. And I'll put a couple of subjects on the table. Michael, for example, there was an article you published with Tony Ficarata. I hope I pronounced his name correctly, by the way. I love the title, definitely provocative, and I'll give you a chance to talk about it. Cross-contextual behavioral advertising is a sale. It's time to get over it. It's an important subject, and Michael, you and I have talked about this a fair amount on other webinars. But when you look at the enforcement decision that came out from California, the California Attorney General, just a few months ago, involving Sephora, there were some critical exchanges that came up in that in the press release. I'm just going to put a couple on the page so we can all look at them together. This is one that has definitely caught a lot of folks' eyes. If companies, I apologize, make consumer personal information available to third parties and receive a benefit from the arrangement, such as in the form of ads targeting specific consumers, They are deemed to be selling consumer personal information under the law. And one reason I highlight this is actually California Attorney General enforcing CPRA, not necessarily even CPRA, which is an important thing for us all to realize. That's a FORA enforcement press release. Also had this critical language, both the trade of personal information for analytics and the trade of personal information for an advertising option constitutes sales under the CCPA. And then, of course, you have the requirements that they lay out, which is to help consumers who want to easily opt out. The CCPA requires, by the way, this is again focusing on the CCPA, not the CPRA, that a business takes steps to ensure that any user who has user-enabled global privacy controls is treated the same as users who have clicked the "Do Not Sell My Personal Information" link. So I put these up there because obviously this is part of what has formed, I suspect, the basis for the article that you published, Michael. But do you mind talking a little bit about what you covered in that article and why? Why is it that you sort of lay out the position that a cross-contextual behavioral ad is now a sale of data under, say, California law?
Sure. So what prompted me to write the article was a position I began to hear percolating in the same way I began to hear things percolating in 2019 about the narrow definition of sale that concerned me. And if you recall, there were certain industry actors who said at the time that targeted advertising didn't involve the sale of personal information, and took a very narrow view, saying that it wasn't supported by consideration. At that time, I thought that was not a terribly strong argument, and felt pretty confident that the regulator would not take a narrow view of the law that it is enforcing for the benefit of actors in the digital ad ecosystem. So I think there probably should be a good deal of humility that should have resulted from that exercise, because it caused Alistair McTaggart to push for an amendment that covered cross-context behavioral advertising, but did not require valuable consideration. So he said, I hear these lawyers coming up with, what they think are these smart legal arguments to try to get out of the opt-out. And so I'm going to amend the statute. While I think the statute's clear and it's covered, it actually, for the benefit of the doubt, I'm gonna cut off that argument. And so, as we know from history, which I think ultimately culminated in the AG's enforcement action with Sephora, is that it in fact determined that sale was quite broad. And in fact, you could even make the case that the amendment for opting out for sharing for CCPA purposes wasn't necessary at the end of the day, given the breadth in which it was ultimately enforced. I mean, you saw in those quotes that you shared that the option of using targeted advertising in itself is a form of consideration. And so I think that the 2022 version of the 2019 narrow definition of sale, where folks were coming up with really sort of smart ideas to narrowly construe things, began to percolate. And so what was driving this? Well, there's still angst in the industry around saying that you sell personal information. Nobody likes that term. It sort of has this connotation that you're in this shadowy place doing something nefarious with consumer information, which is not the case. But you can imagine chief marketing officers at companies that have very important and prestigious brands being concerned with saying that they sell personal information. And so what I began to see a little bit of a growing sentiment among certain industry actors was to say, but with CPRA coming into effect, that must mean that amendment somehow divested cross-context behavioral advertising from the sale bucket. And now it's just a share. So I don't need to provide consumers with an opt-out of sale. I'm just going to provide them with an opt-out of sharing for cross-context behavioral advertising purposes. And nothing could be further from the truth when you look at the historical lens in which the CPRA amendment was enacted. And if you look at the structure of the law, CPRA does not create distinct and separate buckets for a sale and for a sharing of personal information for cross-context behavioral advertising. Rather, those are overlapping concepts. And if we think back to what Alistair McTaggart said, it's a sale, but just in case, I'm going to make it a share.
By the way, I want to make sure I give. You're covering a lot. That's the only reason I'm interrupting, Michael.
Sure.
Already we have questions coming up. And I promised I would do this. What is a cross-contextual behavioral ad? That's an interesting question, right? Because there is some definitional. It's not like it's a measurable quantity in the universe. You know what I mean? Like a meter. So would either of you mind giving a quick walkthrough of what a cross-contextual behavioral ad is? And Michael, you and I have talked about this far. I know you've spoken about this, but the whole concept of when is somebody a service provider versus where is somebody not a service provider under California law is also a bit tricky. So could I hand that to either one of you to cover briefly? And then Farah, one question for you and for Michael. What's the role broadly in your view around the role of self-regulatory regimes as you have laws coming into effect? One last thing, Farah, if you have any perspective from the NAI on whether a cross-contextual behavioral ad is a sale of data. I don't know if you have have a position yet. We'd love to hear how you're thinking of it. So I gave you a lot. Take it and jump in where you all feel comfortable.
Sorry, I've been talking for a while. Do you want to take it, or I'm happy to?
I'll let you take CCPA since you were just speaking on that, and then happy
Sure.
to jump in on the regs.
Yeah, I mean, so there's a statutory definition of CCBA, and in the same way that there's a statutory definition of targeted advertising in the 4 other states, which is essentially using the consumer's personal information from different contexts across the web or mobile or other environments to serve the consumer with an ad. And that sort of cross context differs from other forms of advertising, such as, let's say, contextual advertising, which is based upon an advertisement is based upon the consumer's experience on the first party site, or an ad that is based upon personal information collected by, let's say, the publisher on solely as it relates to the consumer's interaction over time with their digital property, right? It lacks that cross-context component to it.
Farah, do you want to jump in on any of these subjects?
So I'll tackle where self-reg comes in. And I think this is where we get into, you can't just look at CCPA's definition alone. Then you've got to look at the definitions of third party and service provider. And I think where it starts to get complicated is how do you operationalize and implement all these intersecting, definitions that don't line up cleanly. And I think that's where self-regulation can help, right? Up until 2 years ago, I think it was safe to say that technology outpaces the law. That's gone a little bit sideways with some of the requirements we're seeing. But I think generally that's still going to be true, right? And so I think where self-reg can help is closing that gap when these are incredibly nuanced laws with a lot of detail. And then what do you actually do isn't a straightforward answer. Not even, Michael speaking to the contractual pieces, but also operationally, like what are you training your teams? What are you turning on and off? And I think that's where self-reg can help in trying to work in, across the industry with participants to come up with what are some of the ambiguities and what are kind of best practices and guidances of how you actually navigate some of these nuances and pieces. I think the other thing is generally most companies want to be with the herd. So self-regulation and working with, industry trade bodies helps you get that benchmarking of how are people approaching this? What is, maybe step one? And I think, right now with the number of laws and the amount of confusion, there's a January 1 effective date, but we're seeing the parts of CCPA that are affected by CPRA don't go into effect until July 1, and then we have enforcement. So, unfortunately, I think it's going to be a busy, first two Q1 and Q2 for 2023 of figuring out how do you take these kind of principles and these definitions, and then what, I wish I had the magical answer for everything of here's the checklist, you do these 5 things, you're set and you're golden, but I think, we're not there. And I think there's even final regulations aren't out yet on some of the nuance here. So I think part of what self-reg can do is when there is final regs and some of those implementing, guidance out, come together to come up with standards that work across the ecosystem and the different parties to address some of these requirements. Also where there is just, I think an area we're going to continue to work on is on health, where there's a ton of ambiguity of if you take everything as health, then what do we do, right? Businesses need to come up with pragmatic step 1, 2, 3 of how do we start to address some of these changes? And then also how do we move when we see enforcement actions or, other industry norms coming up, but that are kind of shifting where things are going. So I think one of the things the NAI is making sure is that we're not overly reactive. There's still a lot happening. We want to have those conversations. We want to have those discussions. We want to see what's happening before we try to forecast and finalize everything, because there's just so much change and so much uncertainty right now.
Makes a ton of sense. I'm going to go. I knew we were going to kind of end up running out of time. So I'm going to put up a couple of things for all of our viewers here today, if you guys don't mind. Hold on one second. For folks who are joining, our panelists have put together a couple of resources that we're going to be posting as follow-up. So if I may, from Farah, from you and the NAI team, there will be a list of resources from NAI. By the way, can you all hear me okay? I apologize, it's a little perfect. A list of resources from NAI around these issues. Michael, your team put together a terrific resource on how the MSPA works together. And we'll be pushing this out to folks who are coming. Michael, I hope I put up the right thing, just looking at your face. Perfect. And we have put together a couple of resources to enable privacy folks to be able to start the conversation around this cross-contextual behavioral advertising with your marketing teams. And these are 3 critical questions that we have put out to help privacy folks expand the discussion of what is a sale of data without asking the question, are you selling data? And these kinds of questions allow you to expand the conversation, understand some of the marketing practices that are going on in your organization, and be able to cover some of the items that both Farah and Michael were covering in terms of, are you in fact effectively selling data under these laws? So I knew we were going to run out of time. I'm going to read one question that has come in, and I'll turn it over probably, Michael, to you to answer next, since Farah just covered this one. It covers something of what you spoke about a moment ago as well, Michael. The definition of cross-contextual behavioral ad is incredibly vague, tautological, and you can't be a service provider for cross-contextual behavioral ad purposes. How does the MSPA enable companies who are not sure if what they do is a cross-contextual behavioral ad, which isn't a business purpose, or just ads and marketing, which is a business purpose, select the appropriate mode? By the way, I just, on the fly, just because I'm proud of this, I decoded 8 separate acronyms that were built into the question. So you give me credit for that. Our questioner actually just liberally sprinkled nothing but acronyms. But Michael, if you get what they're getting at there, do you mind jumping in with your view?
Sure. Well, I'm not sure that it's incredibly vague. I mean, I do think that there is a reasonable statutory definition and where the outer limits are of what constitutes cross-context behavioral advertising is something we've obviously given a lot of thought to and is embedded in the MSPA, right? Because you're either engaged, let's say for California purposes, in either cross-context behavioral advertising, which would be a share or a sale, or you're engaged in certain other activities, maybe perhaps related to reporting and ad delivery, which could constitute a sale of personal information. So I think importantly, the question gets to, well, how do you deal with the fact that service providers have these limitations as it relates to cross-context behavioral advertising? And so, in fact, California is different than the 4 other states in that regard. And this is an enormous challenge, in particular for brands who've organized much of their compliance frameworks for CCPA around this. And there's no end run to be made. If you're an advertiser and you have service provider relationships, whether you leverage the MSPA or you leverage your own contracts as service providers, you can't upload your CRM data to your DSP and say, go target this audience. That's no longer permitted in California. But what we're trying to do with the MSPA is be able to tell that advertiser, if that's what you want to do, you want to take this exclusive service provider approach. You don't have to. You could also use opt-out option mode. But if you're going to take that service provider approach, you still need to be able to, you'll still be able to reach other audiences, perhaps buying off of other third-party segments, not matching it to your own, where the consumers, where you can't engage in cross-context behavioral advertising. So maybe you're going to also purchase, directly, or you're going to, purchase off publisher first-party data, or you're going to purchase off some other segment. So there's a number of options that are open to them, but what we're still trying to facilitate is how are you going to be able to measure? How are you going to be able to still frequency cap, which are essential to be able to keep the lights on for advertisers. And so the MSPA tries to facilitate those things.
That's perfect. Well, why don't I do just a quick, I'll just say on behalf of the whole community, thank you both for what NAI and IAB have been doing. It's been a lot and there's a lot coming. Farah, thank you, and Michael for the leadership you all are showing here. I'll turn it over to you just for a quick 1-minute closing if you have any. And then I'm gonna just, we have a number of really terrific sessions coming up today that I want to make sure I point out for our viewers. So Farah, do you mind if I give you first closing remarks and then over to Michael?
Sure. We didn't even get to a whole section what the NIA is doing, which is the advocacy work. And I really do want to plug that because I think when we talk about all the confusion and the ambiguity and where we want clarity, that's where interacting with the regulators, through industry coalitions and industry associations can really make a difference. And, the NIA has really stepped up, not only working with coalitions, but directly doing some of that commentary. And I think if you look at our comments, they are dense, but they do have some guidelines of how to think about some of these issues and how to implement them. And, the NIA is very proud. For instance, we've been working very closely with the Colorado stakeholder session in November. We were the only digital trade there. So I say that just to say that we're really focused on working with regulators and putting that input in our public policy working group. Not only can you stay abreast of those information, but we want to hear from you and help represent the digital advertising ecosystem.
Farah, thank you. I didn't mean to exclude that. I just knew we were going to run out of time.
No worries.
Today. So we'll make sure to bring that up on another session. And Farah, I hope you and NAI will continue to join our spokes community here in the coming months. So thank you for being with us. Michael, over to you. Closing thoughts.
Yeah, so I think we are at a very critical inflection point in privacy compliance. We've got 5 new state laws that are coming online, but we also have what I think is a sea change happening. And sometimes in the desire to make sure that you check off all of the boxes, and there are a lot of them to check off for those who are involved in privacy compliance right now, that we lose sight that, as you said, the industry is becoming increasingly regulated. And if you look into the draft regulations that the CPPA put out, there are concepts in there such as parties, not talking about when there are service provider relationships in place, but parties need to undertake diligence with respect to those whom they sell personal information to in order to not have liability for their wrongdoing. That is an indicator of a sea change that is happening, and hopefully we're going to be providing the tools through the MSPA and the GPP and perhaps some other items to help the industry adjust. And so, if there's one parting thought as we move into 2023 and we look up and try to poke our heads above the forest to see that the landscape is really changing from a regulatory standpoint, and that we need to do the best job we can to comply and think strategically about this landscape that's ahead of us.
Michael, thank you. That's a perfect note. So let me just thank you both, and I'm going to briefly walk through our agenda for the rest of today. Michael, Farah, thank you so much for joining us, and we look forward to having you both on upcoming spoke sessions.